Thank you for coming. My name's Toomey. I'm the Registrar of Deeds.
I'm Stephanie Fattman, Registrar of Probate.
And this idea was born. Stephanie was going out kind of talking about probate, and she called me up and said, I'm getting a lot of questions about deeds. And, you know, how do you want to do that? I said, can I come? So now you get the two of us at once, and it's a roadshow. So we tend to describe our jobs a little bit and give you some pointers and guidance and get it going. And we encourage questions. Most of you come with questions. You've read the blurb that we were coming, and usually there's a whole stream of them. This is being taped, so if it sounds like you're soft-spoken, I'll repeat the question so that we can get it on the audio. But we're here for you. We're your elected officials. We run these offices, and we want to be available. So that's why we kind of came out and, you know, we're showing our faces saying, post-COVID, let's help you out. So at the Registry of Deeds, I represent 55 communities, obviously including Shrewsbury, and I am the holder of all land documents, everything from where Spags is to where the DCU Center is, to you name it, I own it. So every cemetery, everything. So I handle all the documents, and as most people say, your biggest asset is your home or your business. So a lot of questions come after they've seen Stephanie at probate, what do I do with the land? Because we go hand in hand a lot of times. You need some authority from the court to do stuff after you've passed at the Registry of Deeds. So that's what I am, and that's what I do.
And I'm the Registrar of Probate. My job is to oversee the probate and family court for all of Worcester County, so the 60 cities and towns of Worcester County. I handle all of the documents that come into probate court. So from probating an estate when a loved one passes away to divorces, child support, child custody, we handle all legal family matters. Also an elected position, was elected in 2014 and re-elected in 2020. So very thankful to be able to serve the community and try to get ahead of going to the probate court. Our whole goal of this presentation is to have you avoid ever stepping foot in probate and family court. We want to give you the information you need to set yourself up and set your estate plan up so that you can hopefully never see me in the court system. And so with that, like Katie said, I think we found the best formula is to answer some questions. If anybody has anything that really helps them,
if you want to start it, if not, we'll keep going.
Or we can keep talking.
We're lawyers. We'll talk all day long.
Actually, I'm Renee D'Argento. I'm the outreach coordinator here, in case you don't know me, and I have some information on advanced planning directives.
Cool.
And I didn't make a lot of copies. I wasn't sure how many people were going to be here. So if you decide you want a copy of something, let me know and I'll make it for you. I'm going to leave them over here.
Perfect. And with that, in our packets, we both provided resources as well. For the probate and family court one, you'll see my name and face on the cover. We have some resources. One of the first I like to guide you to is the attorney referral service through the Worcester County Bar Association. So once we get going and really spark your interest and get you thinking about your estate plan, if you're looking for an attorney, the attorney referral service is a really good place to start. You can enter some information and match up with an attorney that can meet some of your needs. We also have additional services in there, our court service center, some different guides on getting started on your estate plan. And I know Katie has her packet as well.
I have a glossary in there. A lot of people ask how they own their property. A lot of people talk, a lot of questions today. I guarantee you either have it in your head and somebody else will ask it, or you will. Can I add my kid to my deed? Do I do this? Do I do that? So those are the questions that are frequently asked. So we've kind of punted and gotten ready and given you some data on that. You're always welcome to email us if you're an email person. We do have telephones. We still operate in the old-fashioned landlines. You can call us. We'll talk to you. We're there for you Monday through Friday, 8:15 to 4:30. I saw a question in the back corner, ma'am. Yep.
So I'm not sure how this relates to all this, but you keep hearing all of the ads, at least I do on the radio, about title insurance.
Yep.
Yes.
And I did research on that, and it said that it doesn't really help ahead of time, because if somebody tries to get it, they've got it, and then they might know and let you know later. So I don't really know what to believe, and how do you protect for us for that?
So in your packets in there, we had a service for a while. We had some software glitches, but my boss, who's Secretary Bill Galvin, has brought back, with our influence and our pushing, what's called the consumer notification. You're spot on, though. Those ads drive me nuts in the capacity of deed fraud exists, but I'll be candid because I can be no other way, ask my mother. The majority of deed fraud occurs with family members. Statistically, generally, it's somebody who is taking advantage of an elderly or a infirm or unwell family member or a child. And that's normally what happens, saying they're going to help them, but then money gets away from them and they end up taking things. That being said, the Registry of Deeds is the last place anything gets recorded. If something is fraudulently recorded, I ask you to put the emphasis on the word fraudulently. If it's done illegally, it's not valid. It doesn't mean it's not a headache for you, and I'm sorry to say, I've had a few calls where people have called in and said somebody has stolen my identity, and they have to go through the process with the police. I know the district attorney's office, Joe Early's been at the library, I've been with him, he's done some senior scams and some other presentations similar to this, and it kind of piggybacks on that, is if somebody takes it, it's not valid if it's fraudulent. If you didn't sign it and you own your property, it's not valid. It's just a nightmare to undo. And there's not much I can tell you, I'm sorry, other than that, but again, I'm candid. I've been a proponent the last about year and a half. People asked, is it worth it? Somebody tried to open up a business account in my name for my law practice in Worcester, Maryland. And the bank got to the point where they got to one point, and then I got some stuff in the mail, and I called, and the woman was very nice when I got the package in the mail in Worcester, Massachusetts, and she said, we've already initiated a fraud account, it's been shut down, nobody's gotten anything. And I said, do they have my social security number? She goes, I assume they do. So I had a full-on panic attack. Not really, but I freaked out and immediately called LifeLock. I did all my research online. I have been paying for LifeLock personally for the past year and a half. It costs me about $38 a month. They monitor my real estate property, my credit cards, my checking accounts, and they also offer me on my smartphone, which we all live with, what's called a VPN, a virtual personal network, so that nobody can see when I'm on Wi-Fi. That's something I can afford to do right now, and to lock my stuff down, but they offer $1 million insurance policy if somebody tries to fraudulently steal your property or any of your other things, and they pay to fix it for your $38 a month. Gentlemen, yes.
Did you say something about consumer notification?
So, yep, thank you, I got derailed. So in your package, there's a flyer, but we have what's called the Consumer Notification Service, which we refer to as CNS. And if you go to our webpage for the Mass Registry of Deeds in Worcester, and you scroll to the bottom, there's a link right there, and you click on it, and you basically sign up with a valid email address, and you identify your name and your property address. You can do up to 3 properties in Massachusetts per sign up or per email. And if anything gets recorded, they'll ping you with an email and say, let's say you pay off your mortgage and you get a discharge. They'll send you a notice and say, hey, this has been recorded on your name. So it's kind of fun for people to see when things happen. But it's after the fact.
Because I go there.
And you check on a regular basis? Very good. I like people like you. We like when you go check it out. There's a lady in the back in blue. Yes, ma'am.
Could you explain what title insurance is and why do we need it?
So there's 2 things. There's title insurance when you purchase your home. Sometimes they'll sell you what's called title insurance, and that's verifying that the title is clear up until the day that you close on your property, that the lawyer who did your closing verified everything and made sure it was clear and marketable. Then there's these, are you talking about the infomercials that you see on TV when they talk about that?
Questioning, like when I bought my house,
Okay.
I didn't hear anything about title insurance. What is it protect exactly, and why do we need it?
So I'm a big fan of insurance, period, no matter what kind you say it is. But it basically says when you purchase your home, if you purchased it and it was, let's say it was farmland here in Shrewsbury that some family that's lived here for generations had broken it up and made it into house lots, and they sold off the lots to build these beautiful homes, one of which might be yours, and you live in this beautiful home, and then out of the blue, some guy shows up and says, I've been living in Montana for the last 18 years, but that was my Uncle Jimmy, and I have a right to his estate. That's not your house, that's my house, because they didn't probate it correctly. Title insurance would protect the title of your home up until the day you buy it. So everything that the lawyer did prior to that basically covers it. It's a one-time fee. You don't pay it each time unless you refinance and you have to do one. Lenders require it. If you have a mortgage on your property, they require it.
So you buy this before the purchase?
You buy it at the closing. And the insurance agent or attorney will sign off saying that they validated everything, and then the policy goes into effect.
Should it stay valid until you sell the house?
It should, but it doesn't have to, but it is valid. If you buy what's called an owner's title policy, it is with you for the entire ownership of your house. But don't be lulled into anything you've done after you bought the house. It's from the day you bought, we'll say January 1, 2000, before. I saw a hand over here and I saw a hand over here. Yep.
If I want to put my children on my deed
Mhm.
before I die now,
Okay.
is there a tax implication versus just leaving it in my will to them? If I have them on my deed now and then I die, is there a problem with the basis of the tax?
There is. There's going to be, you should talk to a tax person. I always recommend that based on whatever your financial situation is and how much money you have in addition to your property. But there is a tax implication either way. It depends on how much, if you put them on now versus if you will it to them. As I like to say, Uncle Sam always gets his money. One over here and then you, sir. Yep.
Why do you have to keep on buying title insurance and owner's policy if you refinance when they've already cleared the title?
You only have to buy an owner's policy once, and if somebody's selling you one, you should tell them to go pound sand. But the lenders will constantly get a new one in their name, and there should be a reissue rate if it's the same lender, and it should be reduced each time, and it's based on the loan value of the mortgage.
How do you know?
You ask the lawyer who's closing it. When in doubt, please ask questions. You are next, sir.
So one of the leading question after this lady asked is, if you put your children's name or somebody else's name on it, does that property when you die goes direct to them, or it still has to go through probate?
With regards to real estate, it depends on the type of ownership, and we put the different glossary terms of the type. If you have rights of survivorship, it would avoid Stephanie. That's how you avoid her. With regards to land and dirt. But if you don't put joint tenants with right of survivorship and you just put tenants in common, then you go see Stephanie because you've done it in the wrong type of ownership.
So how do we know what kind of?
You have to look at your deed. You're welcome to call us if you're not savvy to use our webpage like this gentleman who checks his title all the time. We can teach you how to use our webpage. All of our records are online dating back to 1731.
Okay. And
Yep.
then if you find out that it needs to be changed to something else,
We recommend you always hire a lawyer because those are questions you should approach a lawyer with, but we can give you a little bit of customer service and guidance on how to do the template type of situation. Yep.
thank you.
Ma'am, in the back in the denim jacket, you had a question?
Oh, yeah, but regarding to what the lady said, that if you want to put the deeds, also the name of your children, you say that taxes, we have to pay. However, we already, when we bought the house, the taxes were already got it from it.
So whenever anybody sells or transfers a property, if your property when you bought it was worth $200,000, and when you die and your kids, if they don't stay in it and they sell it and it's worth $700,000 because of today's prices, they're going to pay on the difference of the money that the value increased.
Okay, the profit. But the kids is still living there.
Good for them. They got a free house right now. You're a nice mom. Will you adopt me? As long as they're living there, it's until the property transfers that there's an issue that triggers a taxable event.
Okay, because if, I transfer them now,
Mm-hmm.
because they're still living there.
Right. If you transfer now, but when they go to sell it or they transfer it down the road, eventually you can kick the can out for a while, but eventually the government catches up. They want their slice of the pie.
Okay.
Yes, ma'am. Back.
So is there an alternative to that when you have children and you have properties, one or two houses? Is there an alternative to putting a name on the deed, or you do something else with the houses to eliminate?
That's when you talk to Stephanie about estate plans.
That's what it, I see.
Yeah.
So then it becomes an estate thing. I'm not really, a little.
So that's the good thing about this presentation, at least, is to get you started on thinking of
A
that
lot of
estate plan.
questions, yep.
And you guys are already starting with some great questions, and I think that at very least leaving here today, you should have some idea on preparing an estate plan that will work for your family. As much as we want to give you an easy answer, there never is one because everybody's family is unique. So we always talk about avoiding the probate court, and there are certain ways to do that. And so first, you're going to have kind of your roadmap. You're going to have your will, the will that's going to guide where your assets are going to go upon death. And so you can always leave a property to a family member. It's a little bit more complex. You'll likely still have to come through the court system. We talk often about trusts, putting the property in a trust. You're going to want to work with an attorney on that. Very complicated. There's a lot of different pieces that go into a trust, so you're going to want to work with an attorney that can help find the right trust for you. And then with your estate plan, you're going to just be thinking, how do you want things to pass upon death? And so what we see often with property is people aren't always thinking, they think, I want to leave the house to my daughter, but God forbid your daughter passes before you. Then where does it go? Does it go to her children? Does it go to her spouse? So these are the type of things that you're going to start thinking of. What happens next? You want to have all of those ideas thought out and brought with you to an attorney, and then the attorney can help you start putting that together into your will.
Just to follow up, so I'm looking for an estate planning attorney.
So
Correct.
at the beginning, I had mentioned that you have the attorney, the lawyer referral service in there. That's a great place to start. You can Google, you can search. I say, ask friends, word of mouth, recommendations. We always tell people you don't have to be stuck with one attorney. If you meet with them and something is just not connecting, it's not working well, you can always look for another attorney. You want to feel comfortable with them. You'll be sharing a lot of information, all of your personal finances with them, your life with them, so you're going to want to feel comfortable with the attorney.
It's like going to the doctor.
Yeah.
If you're going to tell them your personal stuff, you want to make sure you like them and you're comfortable with their answers. And there's no shame in saying, I don't like you, and go and calling. Up to you how you handle that. But if you just don't call them back and go somewhere else, you should shop it a little bit like with doctors.
And Katie will say she worked in private practice for many years and has, you know, a 15-page questionnaire that she'll hand out, and you think it seems like too much or intrusive, but it's important, all important information, because as I mentioned, this happens, it triggers this. This happens, it triggers that.
And you may not think to tell your lawyer and say, well, why would you need to know that?
Yeah.
And it just gets a dialogue going.
And then once it's not done properly, that is how you end up in probate and family court, and that's what we spend our days kind of sifting through and trying to figure out how somebody can get the outcome that they want. But it can be long and complex, time-consuming, expensive. It can get very expensive. Famous line from these presentations is
if you don't pay for it yourself and set it up, your family's going to pay for it on the backside with Stephanie.
So it's important
either way,
to
we're
get it
gonna
all
pay.
together now.
If I might interrupt?
Yeah.
Absolutely.
I bet the questions will keep coming for 90 minutes, so I would recommend going to the presentation and then answer questions after.
Sure.
Sure. I think we kind of guide our presentation
Based
around
on that,
the
but
questions.
we're happy to, whatever. Yeah.
So you want to ask question now? Or you
Sure, keep going. We'll do it that
Yeah,
way.
we'll make sure all the
We
information
don't do
we have gets out.
PowerPoint. We
Yeah.
find that people come here, they have very specific, we've been doing this for about almost a year, and people have very specific questions, so sure.
So another question is like, say, some people, or let's say I have different type of account, like say savings account, checking account, IRA, any of those kind of things. In order to avoid any of those things, there is some specific thing needs to be done for every different account, right?
So you're going to end up in probate court when you have an asset that doesn't pass directly to somebody else. So if you have an IRA where it passes to a beneficiary, that's not probate property. If you figured out the deeding of your house and can avoid probate that way, not probate property. Bank accounts, if you put another name on the bank account, also a way to avoid coming to probate. So anything that is in your name only, that's not going to pass to another individual upon death, that's assets that you're going to probate, have to come to probate court. So, for example, if I may, if you have a bank account and you're the only name on the bank account, for your daughter to access that bank account, she can't go to the bank and say, I'm here, I want to collect the money. She needs the court document from us saying she can access that money. And that's how she has to come through the probate process to get that court document, to take it to the bank and access that money. So,
But in that, let's say if it's a joint account.
Sure.
It will pass directly to the.
Automatically, when you
It
pass,
will.
it's hers.
And if, even though there's a joint account, and if there is something like, either POD, like paid on death, or a transfer on death, if that third person name is written, third, fourth, whatever.
Excuse me,
Yeah.
I have a request to repeat the question.
Sure.
Because people are having a hard
sure.
time.
Sure. So he's got an account where he's got paid on death. accounts, almost like a beneficiary listed as opposed to a joint account. So he's asking the process. It's going to depend on the lender. It's going to depend on the bank, on what they provide, if a death certificate and identification is enough, or if they need the letters of representation from Stephanie's office. That's something you ask each individual bank.
So there is a different scenario with a different entity?
So you have to ask each entity where you have your money what they want to do for the procedure. So if you have a bank and you're joint owners, if you die, automatically by law it would go to the other owner. Upon your death, they don't have to do anything because they're a joint owner. If you do it as a beneficiary, that you have to go through the bank's rules on how to do it. We don't control them.
Okay.
So you have to ask at the bank.
But your bank will know, and they usually have a form you can fill out to list a beneficiary if you choose to go that route. So again, all assets that you have that transfer to somebody else upon death, that's how you avoid probate court. The best way to keep passing things along.
Oh, I saw this gentleman in the
Yep.
tan, yeah.
Just a general question. For a couple that owns a house, when the second person dies, is there a list or checklist of documents that already should be in place?
We usually recommend you contact a lawyer, but are you, so you're a surviving spouse, is that what you're telling me? Or the second person?
The couple is now gone.
They're both gone.
The second person dies.
So then it's going to depend on who was on the deed, and if nobody was a successor or a co-owner on the deed, then you have to go through the process of a will or a trust at the probate court.
And hopefully that's, as I said, what is sparking this thought.
At least a will.
So at least a will, exactly.
You got her number.
Hopefully this presentation is at least sparking that thought that you have a will in place. That will is your roadmap of how your assets are going to pass upon death. As I'd mentioned, it can be complex because you don't know if you're going to pass or your spouse is going to pass first. And then if you've left the asset to somebody and they pass, where does it go? So we say often, have your will updated at any major life change, a divorce, and death, a birth. Any major life change should trigger another look at your will, or every couple of years, every 3 to 5 years, taking a look at it. Because if your will has things in it that are no longer valid, you're ending up in probate court and there can be more complexities. You want to make sure it's up to date and it's exactly as your wishes are laid out. That's the goal of the will. And you can determine where that asset goes. Like Katie said, it's your biggest asset. It should matter to where it's going
goes
next.
There's a guy in a blue shirt. Sir.
Thank you. My wife and I own a home here in Shrewsbury. We're looking at creating a trust and to put the house in the trust. We have 2 kids that would just go to them too, and that's what the trust says. The draft trust is not signed off yet. Do we need to do something with the deed? To put the deed in the name? I've heard they need a quick claim deed, they need to change the deed.
So I assume you've gone to a lawyer. So this gentleman's asking about trusts. I assume that you've gone to a lawyer who's drafted the trust.
Correct.
Good. Hopefully the lawyer will know that you have to put, depending on the structure of the trust and what your lawyer has designed based on your conversations, you generally deed the property into the trust. Alternatively, there is what's called a pour over. So if it's in your will, that it stays as you guys owning it today until you're both gone, and then it pours by the action of the will or the roadmap into the trust upon the second spouse's death. So it depends on the actual document that you and your lawyer have discussed.
And that's different than a quick claim deed?
A quick claim deed is just, I call it the quick and dirty. It's just basically saying, a lot of times if people get divorced, they do a quick claim deed taking one person off, or they add their child, or they get married or remarried or whatever. And a quick claim deed is adding someone on. We also do quick claim deeds when you transfer property. So if you sell Shrewsbury and you move to Northborough.
You can't transfer it to a trust?
Yes, you can. Absolutely.
With a quick claim?
Yep.
Okay.
So there was one question of the peanut gallery than you. Yes, striped sweater, ma'am.
Are all of these things that you're saying apply to a second or seasonal home, or are the rules different?
Where is your second or seasonal home?
Odd.
Okay, at least you're in Massachusetts. I get blindsided when people say Florida or South Carolina, and I say they have different laws there, or Maine. So I like to make it personal. So my in-laws have a house on Cape Cod. It's lovely. And my husband and I pushed them hardcore, and they did it. They're in their 80s, and they put it in a trust 10 years ago. knowing that, nobody's asked the magic question about Mass Health or Medicare yet, so I'm surprised it hasn't come. That was your question. So should some of us go into a nursing home or something like that and we cannot afford to pay it as a private person, they like to attach our properties. And second homes are a little bit more fair game than primary residences. So a lot of people that own second homes worry about those first because sometimes they have more value. So I would highly recommend, if you're a two homeowner and you haven't done an estate plan, you should take Stephanie's folder and take a look-see at the Worcester County Bar Association and contact and see if you can shop a lawyer. Yes, ma'am.
So can you talk to us about why people should do Mass Health or Medicaid planning and the implications of not doing so?
That's leaving your family with a mess if you're unable to do it. The best thing you can do is meet with an elder law or an estate planning attorney and start preparing and talking about your finances, as well as a tax preparer, and what happens if something happens and you have to go into a nursing home. You can't be prepared enough. It's constantly evolving. The look-back period now is 60 months. There's been talk for the better part of 15 years that it's going to be 72 or 84 months. So anything you do, so like this gentleman, we do a quick claim deed. That starts the clock on your property, and Mass Health or Medicare can look back 60 months. That's 5 years. That's a long time.
But once you're done, or can it, if it changes to 72 months and you've done your...
I can't control Mass Health and Medicare, and let me tell you, they're not nice. So I'm going to tell you, always be as prepared as you can. I have a friend, her husband and his mother had done a irrevocable trust. They put the property in, and on month 62, they sold the property, and she went into a nursing home. She private paid for 2 years and then did the Mass Health application, so now we're talking 7 years out, and they have been struggling with Mass Health for 3 years because they just want to know where the money went. Even though they don't really have a right to it, they want to know where it went, and they are withholding payments at the nursing home to be pains in the backside. So it happens.
I have a Mass Health little primer
Awesome.
up there on how they decide they're going to attach something. And there was, I recall in the newspaper not long ago, and there was also legislation regarding if somebody was living in a property, they featured a woman who was caring for her mom, and her mom had bought the condo, and she was still living there, and they gave her a bill for like $38,000. So, and also I've read about people who are on disability and on Mass Health, and how the family members wind up being responsible for that, even though they didn't go into a nursing home.
Yep, they've been trying to do that too, because the state cannot afford to pay for the baby boomers. If I assume most of you are baby boomers, this glut of people, and they don't have enough going on. I've been reading a lot of those articles as well, and it's nothing better than saying, well, why we're here, preparedness. If you have the ability to do it, plan for it. If you have children, talk to your children, talk to your siblings, talk to your nieces and nephews, talk to whoever you talk to about these things. And if you, beyond everything else we say today, I always am a big proponent of communication. I did this out in Sutton, and a gentleman came up to me after, and he said he had a girlfriend for 38 years and lived in her home, and as soon as she died, the son kicked him out, and he had to go find somewhere else to live because they never got married. And there was obviously no communication between this woman and her son. She had been living with this gentleman for 38 years, and the son said, I don't like you, and I own the house, and kicked him out. So you have to figure out, you either pay a lawyer and you do it and say, here's my roadmap, or you talk to your family and you have to figure it out. But the Mass Health thing is scary.
Any word on the legislation, whether that's going to pass?
I don't know. I don't know the answer to that. I haven't asked in a while. It kind of freaks me out. So you should talk to Senator Moore when he comes in.
And just piggybacking on that thought real quick, those are the fights we see in the probate court, and as Katie said, the communication is what's so important. Having those difficult discussions with your family members, while it's not necessarily legal that you tell them your wishes, you also have to write it down in that will, but at least having the conversation so they can have a starting point, a stepping stone. We also see often that families aren't communicating where the important estate documents are. So when you have your will and it's been drafted and signed, putting it somewhere and letting your family know where it is, not in a safe deposit box. We see that often. That doesn't help. It's locked in the bank, and then the family still has to come through the probate court, probate the estate to access the safe deposit box just to get to the will. But letting them know that you've kept it somewhere safe in your home office, or even with your attorney, letting your family know the attorney, letting your family know what banks you're banking at, letting them know where they can expect to get a mortgage bill from. Those type of things.
Stephanie's
are crucial.
pitching my new book that I bought this week from Amazon. So we've been doing this and we get a lot of questions. So I went on the deep dive of searching for books because this is what I do. And this is a cool book. It's not a replacement for a lawyer. I found it online. It came 2 days on Amazon Prime and it cost me $12. It is and they tell you right on Amazon it doesn't replace a lawyer. I can't emphasize enough, if you have enough assets, talk to a tax preparer and a lawyer. But this is a notebook, and it's basically, Stephanie mentioned when I was practicing before I became the Registrar of Deeds, I had a big questionnaire, and it was to kind of get involved. This is basically a spiral, and I'm happy to pass around if anyone wants to look at it, spiral-bound notebook that says, these are the credit cards that I use. These are my bank accounts. This is where stuff is. This is my PIN number. This is my password for my email or my Facebook account. All of those things, as well as just memories you want to share. It kind of softballs it a little bit. It gives you a little bit more. It's not just hard data, but it's all intermixed. And it's kind of a nice way to open a dialogue with your family and friends and whoever you're asking to handle your stuff, and to kind of collate all that and put it where it needs to be in organized fashion, and kind of introduces that kind of stuff. I thought it was kind of a neat thing. My mother's a widow of 20 years, so I talked to her extensively about where everything is, because my brothers are out in La La Land. So it's me, so I know where everything is, but once in a while she mentions something, I'm like, you didn't tell me that. So you kind of realize that you have to have that kind of communication. So I kind of thought this book was neat, as just to get people, your first step is you came here, and that's awesome. But to kind of just for $12, Amazon will send you this, and you can start filling it in, and it triggers the next question. So, back corner, yeah.
So there are a lot of templates out there, so is it legal to get a will template and record it yourself?
Absolutely.
It is.
Stephanie knows I got a lot of questions for that. People on fixed incomes we did this up in Winchendon, and we had some people that were really untethered about how much it costs to do an estate plan with certain lawyers and what they were charging them for that. Honestly, LegalZoom went out a bunch of years ago and hired lawyers in Massachusetts to draft the documents. So if you're going to go on the deep dive in the internet, I'm a big fan of LegalZoom. It doesn't replace a lawyer. You should be presenting your information to someone and making sure you do it right. But if you're going to start fishing around, I'm a fan of LegalZoom.
And I think with that, especially, it's having those conversations with your family members. You think your family's not going to fight. They will. There's always something that's going to trigger a fight. And so we want to try to avoid that. And so just having those conversations, like you said, just knowing that boyfriend's going to stay in the house and that's mom's wishes. You know that might keep boyfriend in the house. And just having those conversations, laying out your wishes in life, really thinking about where the assets are going to go. We see people fighting over everything from big bank accounts to mom's china set, and just letting your family members know where you want those things to go. We say often, if you can do it, gift it in life.
Yep.
That's another way to avoid a fight in the probate court. If you know you want granddaughter to have your diamond earrings, give it to her now and let her enjoy them, and you enjoy watching her wear them, right? So thinking about where things are going to go and communicating that is the best way to try to avoid family fighting.
Unless you want to have a free-for-all.
So if you want to avoid the probate, in the will, you should write every item that, how does it go, or like, what's the language?
Yeah, the question was to avoid probate, writing every item in the will. I don't think that's possible to write every item in the will.
You have to be the caveat of specific.
Expensive item. Let's say if you put house, that how house will be divided or something like that.
You can do that, but be careful. If you run out of money and you haven't updated your will, and you specifically say, I want Worcester Animal Rescue League to have, $50,000 because I'm a dog lover of rescue dogs, but your estate's only worth $40,000, your kids get nothing. So you have to be very cautious of those specific bequests unless you're constantly taking that will out and taking a look at it saying, what's happened? Did I win the lottery? Did I have to pay for medical bills? Did something happen? So you have to be careful of that. So that's why you really should go through a whole process with a lawyer.
And about, let's say, bank or IRA account, if there is a beneficiary, what comes first, like will or beneficiary? If it is beneficiary listed, it's taken care easily?
Depends on the bank. We're back to that question. It depends on the bank, the holder of the money.
Okay.
You got to ask the bank what they expect if you die, depending on how you've listed your loved ones. Yes, sir.
How often should you update your will?
Well, we use the earmark of big life experiences, but I've told people in practice, if you make the magic age of 60 or 65 or you've retired, I suggest every year or two you pull it out with your favorite beverage, whether it's iced tea, whether it's whiskey, whether it's a milkshake, whatever you want, and take a look and say, have I changed my mind? Do I still like that kid? Do I still like this one? Do I still have that money? Do I, everything changes. I mean, I don't mean to sound funny, but it is funny. Everything changes all the time.
And I always say the life events as well, a triggering point. If somebody passes away and they're listed as your personal representative and they're to help organize your estate and they're no longer with us, that's going to be problematic. You're going to want to change that. I'd mentioned the biggest thing we see is when you think you're leaving it for somebody, that person's passed, where does it go next? Because the legal process is going to pass it down to the next person just through the statutes, but their estate might say it goes to someone else, so it gets complex. And it might not be who you want it to go to if you don't list it.
If I still like my kids, it's okay.
Right now, I hope you do. And let me tell you, spouses make an impact. Yes, ma'am.
So a will is recorded at the probate court?
Usually upon death, but...
Usually upon death. So you can record it with us. It's not necessary. Generally, your attorney will retain the copy, and that's most important. Somebody has that copy. I'd said to have the conversation with your loved ones. They can keep a copy. You're going to need the original if you come to the probate court, but letting the loved ones know where the original is.
But it's a public document.
It will be. Once you file with the probate and family court, it's a public document.
I saw some other hands. We'll be right back, sir, yeah?
Any recommendations for picking an executor? I'm thinking of changing my executor and
So definitely
that's a personal choice and a conversation. I mean, I laugh. My husband and his sister were each put as healthcare proxies for the opposite parents because one will pull the plug and one will not. And again, you laugh, but my mother-in-law is like, I want to be here for the rest of all time, and my husband could never do that to his mother, so she picked him. And my sister-in-law is like, Dad, I'm going to take care of you. Don't worry about it. So that's a personal decision.
And obviously somebody you trust and feel comfortable
Talk
with.
to family, talk to friends, talk to a girlfriend, talk to a friend, figure it out. I mean, you have to kind of feel my mother talks to her friends all day long about how much her children suck. So they all work it all out and figure out which one's the least of the year, and then they get to be the proposed personal representative.
I'm trying to figure out who's would act the fastest rather than just,
That's a factor for some people.
Yeah, it is. And they're still bound by the law, right? So they still have a responsibility to the law in executing that will. So I think it's somebody you feel comfortable with, and if it's no obvious choice like your one and only child, then having a conversation with that person. We see often people just so overwhelmed because somebody's passed away, they've been named personal representative, maybe they didn't know they were going to be the personal representative, they're gathering everything for the estate and trying to get it together. It can be a lot. So it's something to have that conversation about and let them know that you're asking this of them, and helping them hopefully with something like this book put things together on the front end.
If you have a will and in the will you have somebody's name who is not a U.S. citizen or living in a different country, does that cause a big issue to go to the will?
The question was if you have somebody in your will that's not a U.S. citizen or living in a different country. You might be able to speak a little bit better to this, but
on land it's a little dicey, but yeah.
You can leave an asset to someone, and they can claim that asset.
Leave some money behind for the lawyer that's going to fix all that.
Yeah, there will be legalities on how to get it to them.
Yeah.
I keep on hearing, for at the end of this, almost most of the question, look for the lawyer. They don't come cheap in a way.
They don't,
No.
and that's the problem.
But like Katie said, you pay for it now or you'll pay for it on the back end, and somebody's got to figure that out.
So as a consumer, how do you really go to the right person that he or she is gonna do cut pricing for you?
I think by coming to these things and getting some initial information, talking to your community outreach at the senior center, talking to any friends that you make here, talking to your neighbors, talking to your family, will start the guidepost that it gets you going and it gets you deeper in, and then you can go with your book done or your own spiral notebook from CVS that was 69 cents, and you say, these are all the things that I own. These are the way I want it to go. And if you go in ready, you're not wasting somebody's time and you're not paying them all those billable hours. So to me, preparedness is the way to go. So I think if you can do what you're doing and gather as much data as you can now and just make decisions and talk it through with people and then get it done, it makes it a lot easier.
And like she said, doing your research, just talking to your friends. If maybe somebody in the room that you're friendly with has a recommendation of somebody they've worked with and how they felt working with them, that's probably one of the best ways to see if you might click with that attorney and be able to work with them as well.
Yep.
I think I started doing that already, like
Yep.
Make a list of all these different account, password,
Yep.
username, all those things. Because whatever situation I went through, and I say, something needs to be done because there is so many things nobody knows about.
Right.
And somebody needs to know, so I did prepare like whatever 10, 15 page information.
Very good.
And if you then share with the lawyer, then hopefully that.
They can ask all the right questions to say, is this bank account a beneficiary, joint, whatever, and you can check off your list that they're either going to avoid probate or may need it, and they can guide you down to pare it down to a little bit less, and maybe the bill will be a little bit less. I had this woman first, and then over there. Yep.
I had a situation where it happened in the beginning of COVID. So my will was older. My children are in their 30s, and my will was from when they were young. And so obviously we figured it's time to change it. But it was beginning of COVID, and we went to a lawyer that was recommended, but it was through Zoom.
Okay.
And he sent me a lot of paperwork. He sent me a list of things to write down. But and he then sent me a will and a proposal for a trust. And my older will was 2 pages. This will was like 20 pages, and it just made me crazy.
Because we're lawyers, we like to talk.
Yeah. So I put it aside.
Okay.
And I never went back and looked at it.
Well, it's time.
I thought, well, I don't know what I'm going to do. I can't, what is this? Oh, why are they 20 pages? Is it all, the beginning part is.
Well, I hope you have a lot more assets now than you did 30 years ago.
And that would make it longer?
So the laws have changed a little and evolved, and as all jokes aside, lawyers will cover their backside, the CYA, and so in general, they're going to put everything in to protect themselves, but protect you, and to think of the things you don't think of. I agree. I've seen lawyers of wills and stuff of yesteryear that were 2 pages. A very bland, basic will. Stephanie probably sees them a lot more than I do, but sometimes people come to the registry deeds with them. A very basic one in Massachusetts right now, I'd say, is 4 pages.
In 2012, the whole entire probate code changed. And so that could be some of the trigger for why it's a lot longer. But I don't think it being long should deter you from taking a look at it. And it's really important to dig
Just get your milkshake or your whiskey. Or whiskey in your milkshake.
I just wanted to make sure it wasn't unusual.
No, and I think too, now you probably, if your kids are grown and they are going to get different assets, as I said, kind of that
You might be a grandmother, you
gonna,
might have some other tiers to deal with and some tax ramifications.
Yep.
Yeah. We'll come back. Green jacket. Yeah.
I have a totally different subject question.
Sure.
Because you represent family court. So my son's wife left him 3 years ago. They got a divorce. He wound up paying X amount of money. He's now out of work. Can he go through family court, or does he need a lawyer and go someplace else?
Well, yep, so he's going to want to modify that through the probate and family court, modify that original order to change what he'd be paying. I always recommend hiring an attorney.
But it would be through family.
Yep, so he's gonna take that order he has and then come in and modify that with us. So, and there's tons of services listed in the packet. He can call us on our virtual registry. He can work with our court service center. Those are lawyers free of charge that are right in the building that'll work with him. So there are different avenues for him to at least get started, but then he should try to find a lawyer that he either previously used or feels comfortable with.
Okay.
Ma'am in the stripe behind her, yep.
So, it was about 5 years ago when we did take a look at our wills again. And when we revised them, one of the things that I hadn't thought of, that the lawyer thought of, was to make sure that whoever we're picking as executor has the access or permission to have access to all of our electronic information. Because so many people are doing everything online with the passwords and everything. And they very specifically wrote it out to make sure that any organization would know that the executor would have the right to all.
Thank you for
that.
bringing that up, that's awesome.
Yeah.
Not a lot of lawyers think of that. Some of the older lawyers don't think about that stuff now, like accessing the cloud and things like that. That's a great,
Well, I thought it was really important.
it's really important.
I didn't think of it.
Yep, nope,
So-
right. Did I see another one? Yes, sir.
There's something about for home, something like homestead or something?
Sure.
That's something you can talk about?
Sure, the Declaration of Homestead is a document that you record at the Registry of Deeds identifying your primary residence. So if you live in the house majority of the time and you pay your taxes there and you identify that as your principal or primary residence, you can declare it your homestead. It's a $35 form. We have them at the registry. You can come in. It needs to be notarized. We have 4 notaries on staff, so any one of us can notarize it for you. And it basically is just a piece of paper, and it's recorded for the world to know that it's your primary residence. What that saves you from is, while you're still living, if somebody sues you, I can't stop them from suing you, but if somebody sues you or tries to collect money from you, they cannot force the sale of your home to fulfill that obligation.
That's the main.
Yes, and I always recommend the statute amends for it when you get over the magic age of 62. I know you guys are all hovering around there, but anybody that's over 62, you get bigger coverage because the theory is you have a smaller or zero mortgage, so you have more equity in the property. So we always recommend it's $35 to record it. I can't waive that. There's no discounts, but it's out there. I will give you the one side thing is that Governor Deval Patrick in 2011 made an automatic homestead law in Massachusetts. So every homeowner has an automatic if you file your taxes and uses that as your principal residence, and it's as an individual $125,000. In this day and age, if you own a home in Shrewsbury, I think it's worth more than $125,000. You guys live in a pretty nice town. I saw somebody over here in a blue or something, or green and gray, and then I'll get the blue after. Yep.
You mentioned quitclaim deeds earlier. Is that a worse way to cut? They claim that quitclaim deeds is the worst way to own land.
No. What a quitclaim deed is from a legal description is you basically give what you own. So it's when we went to law school, we learned that a quitclaim deed is basically I own this property description, here's the markers and all this, and I quitclaim and give you exactly what I received when I got it. Some people talk about a warranty deed and you're warranting that everything's in there. That's lovely if you get it. 90% of them are quitclaim deeds in Massachusetts. It doesn't make it any less valuable. It's just the way the paperwork kind of flows. Ma'am in the blue. Yeah.
I have a family irrevocable living trust now. Can Medicare and MassHealth get into that?
I hope not, but.
You don't?
The laws of Massachusetts are constantly evolving. We were in Oxford a couple weeks ago, and this gentleman came with his binder from a lawyer, and he had a trust, and he was a little disgruntled because he felt that his lawyer, he paid a lot of money for something that he felt was no longer valid. I don't know. I didn't look at his trust. He carried around his big binder, and he was an angry man. But we suggested he have a second look at it, second opinion, just like the doctor, and try to figure out. His wife was at a point where she was having some health issues and she was going to go potentially into a home, and he was getting very anxious about that. So again, like I've said to most of you, it's proactive. You come to these seminars and it triggers you to think about these things. You guys are one step ahead of everybody else that didn't show up today.
Well, if the children are in that, and it's in a trust, don't they actually Part ownership now?
It depends on how the trust is drafted. Right.
I have a second one. It was my husband and I in the trust. He passed on. How do I take his name on?
You're gonna deal with a lawyer on that one. Yeah, because they're gonna have to draft documents to remove him as a trust, and you may want to put a new trustee in to replace him. And you want to kind of get some guidance on that. That's the family conversation, the lawyer conversation.
Okay.
So, absolutely. In the corner?
How long does it take to probate a will? And also, on the homestead, does it protect against a town foreclosing on a property for taxes?
Does not. The homestead doesn't protect you from condo foreclosures on not paying condo fees, towns, IRS, or Mass Health Medicare. They won't foreclose on you, but they will wait until you're gone, but they will sure as heck get their money out of it. Yeah.
Will, how long?
And so if you come in and you file an informal with us, you have to give notice. The world has to know that it's been filed, 7 days notice, and then we can act pretty quickly after that, probably within about a week. But that's not usually how it happens. Generally, something comes up that complicates things. Ideally, we've processed your estate within 3 or 4 weeks, but some of them take years. They can take years. So if nothing is wrong with it, you could have documents that allow your loved ones to access the bank accounts within 3 or 4 weeks.
So if someone has a mortgage on a property, you still have to pay that mortgage, otherwise it could go into foreclosure, so better leave some money for that.
I always suggest that. I mean, it's one of those, it's interesting with each group we've gone to. A lot of people ask questions, but we were out in Charlton, we had a woman who asked a lot of questions, and it triggered a conversation about if you add your children to your bank accounts, they then own the bank account. I hope you like that child, you don't piss them off. Number two is if you have grandchildren that are applying for financial aid for college and they're named on your bank account, that's going to affect their asset list because they're named on a bank account. If you add them to your quitclaim deed, that's also going to affect them if they apply for financial aid or if they have not declared it a homestead and they let the American Express card go a little crazy. So those are all kind of conversations you have to have with your loved ones before you put them on any of your properties.
Or you could get life insurance.
You could get life insurance, which passes outside, or I suggested to my mother, first of all, back to the Mass Health thing that Community Outreach has for you is prepay for your funeral. If you want to have a party, plan for it and plan it yourself and prepay for it. That's the best thing you can do for Mass Health purposes. But also, what I suggested to my mother is to have a small account on the side that she owns jointly with one of us that's enough liquid cash to pay for anything out of the gate should something happen, but isn't tapping into her regular bank accounts right away. That would work for us. Subsequently, I'm now on every account, so it's better that way. My brothers love that. So, that's the family dynamic, and that's just where we're at with it. But I'm the daughter, my mother picked me, I'm the only girl. So, it just kind of worked in my family that way. But it started out with one account and we called it the oh no account. Oh no, something happens. My mother was traveling a little bit more a decade ago, pre-COVID, in Europe and stuff, and now she's traveling a little bit less, so we started kind of changing stuff up because we sat down over a cup of tea and said, what are we doing differently now? So those are the conversations.
But just getting back to, if you have your children's name on the bank account, then they have rights to, they are part owner, correct?
Correct.
Yeah.
But if it is paid on death or
They are not.
then that's different.
That's different.
They'll
Okay.
pass to them
Yeah, that's a
versus
totally
owning
different
it
thing.
with
You
them.
need to make an appointment at the bank and sit with one of the managers and lay it all out and ask the bank how they want to do it.
Okay.
Yeah. Any other questions? We've given you too much information. You guys saturated? I can hang around for a few minutes and then, one more.
Back to the homestead. If you have a homestead and the house is in one person's name, does that transfer to any of the other people, or would you have to take out another homestead?
So if you have an adult child living in your home and you want to make sure that they don't do any shenanigans even though they're not on the deed, they can claim it as their homestead so that nobody tries to attach it. In theory, when creditors go looking for stuff, they're going to go to Mass Land Records and look to see who owns it. If you don't own it, but some people when their children turn 18 or 25 or 30 and they're still at home and they're nervous about something because they're a financial burden or whatever, they will homestead their children. You have every right to declare it as your primary residence, even if you're not the owner.
What if it's in a trust? Is that still true?
There's a separate one for trusts. They've been working on amending the statute on that. I wasn't a fan of it as a practicing attorney for a long time because you had to identify the beneficiaries, and a lot of people don't want that out there. A lot of times trusts don't identify the beneficiaries, and we keep all that personal because our records are all 100% public. I mean, it opens you up to scams all over the place. All of our records are online. So I try to leave, as a practicing attorney, I always try to keep that kind of stuff separate. You don't want your kids' names out there or date of births or towns of residence because people are scanning documents online. So beneficiaries we try to keep out. So you've purposefully, if you are in a trust or thinking about a trust, you're at a certain level of ownership of value that is a homestead really important? Probably not, but talk to a lawyer of how much protection you're already getting from the trust, and is the homestead really going to help in any way, shape, or form? So, yes, ma'am.
Is the Homestead Act just one time you do this, and you have to,
Yeah, they changed it just one time.
just when you originally bought the house?
If you did it when you originally bought the house, it's still good. It used to be back in the 90s that if you were the head of household and it would cover your spouse. So we have a lot of men and women coming in, say the house is in my husband's name, but I'm not on the homestead. Then I bring up you might be over 62, so let's do the senior one, which is helpful, but it still covers you. The statute was changed it was amended that it would still cover you, but some people like to see their name on the declaration of homestead. $35, if it's peace of mind, we're happy to do it for you. It doesn't negate anything. Yes?
So if the homestead was done before the age of 62, do you have to do a senior homestead after?
I recommend you do because you get more coverage. And where the values in the last 2 or 3 years have shot through the roof, you get more coverage. I mean, the home values are ridiculous now. Wonderfully ridiculous, but ridiculous. So, we good?
You don't need a lawyer? Sorry.
No, you don't need a lawyer. You can come see us at the registry. We'll do them. Or they're on our webpage. You can download it and get it notarized at the bank and mail it in. All you have to do is, since I know you're savvy on mass land records, is you just have to look up the book and page of your deed and reference the deed for the property purposes and put it in there. And that's all that you need to look up for that. Otherwise, it's just filling in your name and address and having it notarized. But we love visitors at the registry. We just renovated. We just reopened. It's lovely down there. We're downtown Worcester in the Mercantile Center. I am not in the courthouse. I'm down in the Mercantile Center.
And what's the homestead amount for a single and a couple?
I'm sorry, what? Oh, the homestead amount? Under 62, it's $250 for a single, it's $500 for a couple. For over 62, $500 and $1 million. So, thank you. Yeah.
Even if your homestead was done earlier?
It still will cover you. But if you didn't do it if you're over 62, you might want to look at that of when you did it because you'll have more coverage. It doesn't automatically know when you turn 62. You have to refile. So thank you for being such great participants. Those were awesome questions.
And we'll hang around.
We'll hang around for a few minutes, and if anyone wants to look at my fun book, I'm happy to share.